During a pretrial conference, how much information does the judge really want to know? You want to know the answer? Come join me on this walk through the parking lot as I share with you the answer to that question. Hi, I'm Gerry Oginski. I'm a New York medical malpractice and personal injury attorney. Okay, you sued your doctor for malpractice, claiming that he was careless, causing you significant harm and injury. The doctor, on the other hand, turns around and says, I did nothing wrong, and whatever I did didn't cause your injuries. And then he says, if I did cause you harm and I did cause you injuries, guess what? Your injuries really aren't as bad as you claim them to be. So now your case goes all the way through the litigation process, which means depositions have been done. Each side has been questioned to learn about what occurred and why, to learn what problems you have, the injured patient, as a result of whatever the doctor did wrong. So now, during the course of the lawsuit, we have to exchange medical records. We have to provide permission slips to the defense in order for them to go ahead and get copies of your medical records. All right, great. What happens when all of that is finished? When all of that is finished, now we have reached the conclusion of the discovery phase of your lawsuit. Now, what does that mean? It means that we're now ready to put your case on the trial calendar. So once we finish discovery and put your case on the calendar, what happens then? One of the first things that will happen is that we will have a conference with the judge. It's known as a pretrial conference. And during this conference, the judge will want to know a number of things. He'll want to know, number one, what's this case about? He'll want to know where we are in terms of discovery. Since all discovery is finished, we'll let the judge know that we just put the case on the trial calendar. And you might be thinking, okay, great, that means you're going to get a trial date in a few days. No, that's not how it works. Instead, you're going to be waiting months and months, depending upon how backlogged each county is. So it might be 8 months, it might be 6 months, it might be a year before you actually get to trial. All right, so what happens during this pretrial conference? So now the judge is trying to learn information about what the case involves, and more importantly, he wants to know whether we have made a settlement demand to the defense. If the answer is no, he will then ask us for a settlement demand. And now we will give it to the defense attorney, and then he'll turn to the defense attorney and say, okay, counselor, what do you want to do with this case? Meaning, what is he trying to ask? He's saying, listen, is there a chance we can try and settle this case before you guys go to trial? If this is the first time that the defense attorney hears about the settlement demand, he's going to say, Judge, I don't know the answer to that question. We have to go ahead and evaluate all of the medical records. We have to go ahead and analyze the entire case. And then we have to present this case to the insurance company and wait for them to give us an answer as to whether, number one, they are interested in trying to negotiate. If they're not, then we obviously know we can't negotiate and we have to go to trial. If, however, they are interested in negotiating, now they have to give me authority. They have to give me permission to begin negotiating. And now, when the defense attorney says they have to give me authority, what does that mean? If the doctor's insurance company believes that this case should be settled or needs to be settled, now they will give the defense attorney a certain amount of money, upon which to go ahead and try and negotiate, to try and settle this case. So let's say they give him $1 million, and now we've demanded $5 million. He's going to try and negotiate this case for less than $1 million. If our demand is $5 million, then obviously we're not going to achieve a settlement at that point. However, the amount of money he has been given is $1 million. If he goes ahead and offers that up, now he has nothing left to give. He has nothing left to offer. So let's go back for a second. We're in a pretrial conference. Now the judge has asked the defense lawyer whether or not he has authority to begin negotiating. If this is the first time he's heard about the settlement demand, he's not going to have any authority whatsoever to begin negotiating. So he's going to ask the judge for additional time. Judge, I need a few months to go ahead and present this case to the insurance company to see what they'd like to do. And in all likelihood, the judge is going to allow the defense to do that. And he'll tell us to come back in a few months, hopefully after the defense attorney has had an opportunity to speak with the insurance company, to conference this case, and make a decision about what they want to do with this case. Do they think the case is defensible and the case needs to go to trial and have a jury decide this case? Or do they think the case could be settled, at least begin negotiating to see whether or not there's a possibility of trying to resolve this case without the need for going to trial? So why do I share this quick information with you? I share it with you because this comes up in every single medical malpractice case that happens in New York. Now we've gone through the entire litigation process. It's now time that the judge wants to know what's going on with this case. Is there a chance we can try and resolve this prior to trial? If not, great, I'll give you guys a trial date. You come back in 8 months, in a year, you come back in 6 months, whatever date the court gives us. Now, at that point, we go forward with your trial. You know, I realize you're likely watching this video because you have questions or concerns about your own matter. Well, if your matter did happen in New York, and you're thinking about bringing a lawsuit, but haven't done so yet because you still have questions that need to be answered, what I invite you to do is pick up the phone and call me. You know, I answer questions like yours every single day, and I'd love to chat with you. You can reach me at 516-487-8207, or by email at Gerry, Gerry, at oginski-law.com. That's it for today's video. I'm Gerry Oginski. Have a wonderful day.